Welcome to the debate. Today we're standing at this really fascinating intersection of two very different and perhaps completely incompatible timelines. On one side, we have the Civil Procedure Code of 1908, which is this century-old, highly comprehensive blueprint designed to bring order, precision, and finality to civil litigation. But it was designed for a paper-based world. And on the other side,
we have the technological landscape of February 2026, which is, it's totally unrecognizable compared to the world of 1908. Honestly, it's unrecognizable compared to just 2024. We are working in a reality where the tools of the legal trade have shifted almost overnight.
yeah, it's been rapid.
Exactly.
We've gone from, basic Microsoft Excel to Julius AI, from simple Google searches to the cognitive engines of Perplexity, and even just from typing on keyboards to speaking our thoughts directly into whisper flow. Right, and that is exactly the tension we are here to explore today. The central question for this debate is whether the comprehensive blueprint of legal procedure, specifically the CPC of 1908, whether it provides an irreplaceable foundation that ensures justice, regardless of the tools we use, or on the flip side, has it become a cage that throttles the efficiency offered by this new 2026 tech stack? I'll be arguing that the Toad provides a necessary structure. It's the foundation. It ensures the House of Justice stands, no matter how fast we try to build it.
And I come at it from a very different angle. I'll be arguing that strict adherence to these archaic procedural forms and, well, the Latin vernacular, it creates a massive bottleneck. The 2026 tech stack offers a completely new paradigm of efficiency. And frankly, the old code is forcing lawyers to slow down to the speed of a typewriter when they are literally holding supercomputers in their pockets.
Let's begin with your position then. You seem to view the code as this obstacle course to be navigated as quickly as possible. But I would argue that civil litigation is a life cycle. It isn't just a random series of tasks. It is a process that has to follow a specific order to ensure fairness. If you look at the source material, the CPC is literally described as a practical blueprint. It starts with the foundation, specifically sections 9 through 20.
I understand the blueprint analogy. Really, I do. It's a classic defense of structure. But blueprints are for buildings that sit on physical ground. We are currently working in the cloud. When that foundation was laid in 1908, jurisdiction meant looking at a physical map and measuring actual miles between districts.
I see why you think that, but let me give you a slightly different perspective on what that foundation actually is. Section 9 is about jurisdiction, yes, but fundamentally it is about authority. It empowers courts to try all suits of a civil nature. Section 11 is res judicata, the principle of finality. These are non-negotiable baselines.
Sure, but
Let me just finish this thought. My argument is that you cannot automate maintainability and finality. If a lawyer fails to verify pecuniary or territorial jurisdiction before filing, the plaint is returned under Order 7, Rule 10. No amount of AI processing power can fix a fundamental lack of authority. The code forces you to check the foundation before you build the walls.
that is a compelling argument. But have you considered that the tools we have in 2026 fundamentally change how we determine that authority? You talk about checking jurisdiction like it's a manual process of looking at ledgers and giant books. But look at the shift in just the last year. We moved from reading standard PDFs to using Notebook LM.
Which acts as a summarizer.
No, it acts as a synthesizer. Notebook LM can ingest thousands of pages of jurisdictional precedent, cross-reference them with the current facts of the case, and determine the correct forum in seconds. It doesn't just read, it connects concepts. And then look at how we present that information. We moved from standard PowerPoint to Gamma. The CPC calls orders I through 9 the heart of litigation, referring specifically to the drafting phase. But in a world where Claude has effectively replaced the basic functions of ChatGPT for complex reasoning, and Ideogram 2.0 has replaced Adobe Illustrator for visual evidence, that heart is being automated.
You say automated, I say bypassed.
I say streamlined. The code demands we treat drafting as this bespoke, artisanal process. It forces lawyers to draft endless documents by hand just to satisfy Order V, just to say something that a machine could have structured flawlessly in milliseconds. The code forces us to simulate 1908 labor in a 2026 reality. It's like it's like demanding a mathematician show their work with using an abacus when they have a graphing calculator sitting right there.
I'm not convinced by that line of reasoning because it severely confuses the generation of text with the validity of a legal claim. Let's dig into this a bit more. You mentioned the heart of litigation being drafting. Order V mandates that pleadings must contain material facts, not the evidence by which they are to be proved.
Right.
This is a critical distinction. It requires a human mind to separate a fact from the proof of that fact.
But why can't an AI make that distinction?
Because an AI like Claude is, at its core, a prediction engine. It might generate a beautiful document, but does it actually understand the legal weight of a material fact versus just a piece of evidentiary noise? If you let the AI draft the pleading based on a massive data dump, you risk violating the fundamental rule of pleadings. You clutter the record. You turn the court into a data warehouse rather than a place of adjudication.
I think you are vastly underestimating the 2026 toolkit's ability to parse logic. But let's look at the language itself, because this is where the friction is most obvious to me. The CPC and the legal tradition surrounding it rely heavily on highly specific terminology. We see terms like sine qua non and corpus delicti all over the source material.
Exactly, and I heavily defend those terms.
You defend them? They act as an absolute gatekeeper.
They act as precise coordinates. Sine qua non means an essential condition, something without which a thing cannot happen. Corpus delicti is the body of the crime, or the proof that a crime actually occurred. These aren't just jargon. They are precise concepts with highly specific legal weights. For example, proof of intention is the sine qua non of certain offenses. When we use that term, we are invoking centuries of interpretive history. That requires human nuance, not an AI summary.
I'm sorry, but I just don't buy that. That language mystifies the entire process. It keeps the client completely in the dark. We are living in a world where whisper flow has replaced the physical keyboard for many of us, allowing for a seamless flow of thought directly to text. We have Arc browser replacing Chrome to organize our digital lives into intuitive spaces and flows. These tools are designed for accessibility and speed. They explicitly remove friction.
Speed is not always a virtue in law. Sometimes friction is necessary to prevent grave mistakes.
But clarity is always a virtue. When the code or the legal culture insists on using mutatis mutandis, which just means with necessary changes haven't been made, or inter alia for among other things, it is clinging to a dead language while the rest of the world uses perplexity to get straight answers. Why do we need a blueprint coded in Latin? It alienates the client. If I use ipso facto to explain a contract violation to a client, I'm confusing them. If I use a visualization tool like Nano Banana to show them the breach, they understand instantly.
Nano Banana?
Yes, the 2026 replacement for Photoshop. It allows for instant visual creation and manipulation. If I can show a judge or a client the visual representation of the dispute, that is far more powerful than hiding behind a Latin phrase. The language of 1908 obscures the truth. The tools of 2026 reveal it.
That is an interesting point. Though I would frame it very differently. Precision often looks like obscurity to the untrained eye, but it prevents ambiguity. Mutatis mutandis is a shorthand that saves pages of repetitive drafting. If you had to write out what the necessary changes made to fit this specific context, every single time, your pleadings would be textbooks. It's compression. However, let's move to where the rubber really meets the road here, the trial phase.
Orders 14 through 20, the black hole of the legal calendar.
Correct. The transition from paper to proof. This is where the CPC is absolutely essential. Under Order 14, the judge identifies the issues, the specific points of disagreement. Then, Order 18 governs the critical recording of oral and documentary evidence. This is the human crucible of law.
It is also by far the slowest part of the law.
It has to be. You cannot have a finding of fact generated by Nano Banana or purely edited by Opus Clips.
Opus Clips being the tool that turns long-form video into short, viral clips instantly.
Exactly. In a world of Opus Clips, where reality can be edited in seconds, the physical act of recording evidence of a witness standing before a judge swearing an oath is essential to credibility. Order 18 ensures that evidence is taken in a way that preserves its integrity. If we hand this over to the 2026 toolkit, we risk deepfakes and manipulated narratives. The CPC provides the rules of evidence that protect us from our own technology.
Okay, that is a compelling argument regarding deepfakes. I will certainly grant you that. But have you considered that the CPC also protects sheer inefficiency? Look at in-camera proceedings. The term literally means in private, not open to the public. The example given in the material is protecting a victim's identity. Now, in 1908, that meant physically clearing a courtroom, locking doors, and ensuring no one was listening at the keyhole.
And it is still a vital protection for highly sensitive matters today.
But in 2026, why do we rely on physical courtrooms for in-camera work? We have end-to-end encryption. We have digital tools that offer significantly better privacy than a leaky wooden door. We could conduct sensitive testimony remotely, securely, and with far less trauma to the victim using these tools. But the code insists on the place of suing and physical presence. It forces the victim to come to the architecture of 1908.
Because the court is not just a service provider. It is a place of public record and authority. Physical presence carries weight.
It carries delay. And don't even get me started on Order XXII.
Interim relief.
Yes, interim relief. It's often used just to freeze things. It's a pause button that gets pressed and held for years. The rigid stages of the CPC, waiting for issues to be framed, waiting for evidence recording, they delay the actual resolution. The source material calls Order 21 the bread and butter of practice, but the CPC makes it incredibly hard to actually get there.
I see you are eager to get to the result, but you cannot simply bypass the process. Order 21 deals with execution, turning a paper decree into actual recovery. It is the mechanism that protects property and rights, and importantly, Section 151 allows for inherent court powers to fill gaps. This system is complete. It has a built-in release valve.
A release valve that is usually rusted shut. You call Order 21 the bread and butter, but for most litigants, it's a mirage. The procedural maze is just too thick. Look at the tools we have right now. We have Windsurf, which has totally replaced GitHub Copilot for coding and logic structure. We have Julius AI replacing Excel. These are tools capable of analyzing massive data sets for asset recovery instantly.
How does code help you physically seize a property?
Because in 2026, property is often digital, or at least digitally tracked. If I have a decree, I shouldn't have to file a new, separate application under Order 21 and wait for a bailiff. I should be able to use a tool like Julius AI to trace assets across databases and present that to the court for immediate attachment. But the CPC forces lawyers to draft endless written statements under Order 8, containing only material facts under Order 6, whereas modern analytics could simply present the evidence directly.
Are you suggesting we bypass the pleading stage entirely?
I am suggesting that the distinction between facts and pleadings and evidence for trial is an analog constraint. In a digital world, the fact and the evidence are often the exact same file. If I claim you owe me money, the fact is the debt, and the evidence is the digital ledger. They are one and the same. The CPC forces me to split them up and present them years apart.
That is a highly dangerous conflation. The fact is the allegation. The evidence is the proof. If you merge them too early, you get trial by data dump. You get trial by algorithm. The CPC separates them to allow for a proper defense. Order 8 allows the defendant to actually present their written statement. If we let Julius AI simply find the assets before the claim is fully adjudicated, we are bypassing due process. We are executing the sentence before the trial is even concluded.
We aren't bypassing due process. We are streamlining it. The blueprint describes the CPC as having a life cycle: initiation, pleadings, trial, execution. It's entirely linear. But the 2026 workflow is dynamic. We don't just Google search anymore. We use Perplexity to get synthesized answers. We don't just use Adobe Premiere. We use Opus Clips to edit video evidence instantly. The linear progression of orders I through X21 is simply too slow for the speed of modern information. By the time you reach order X21, the assets have moved, the company has dissolved, or the technology has changed yet again.
I'm not convinced by that. because speed without direction is just chaos. You mentioned Notebook LM replacing reading PDFs. That is a fine tool for summarization. But the CPC requires us to verify jurisdiction under Section 9. Can Notebook LM truly understand the nuance of a suit of a civil nature versus a purely religious right, which is a classic jurisdictional distinction?
It can certainly highlight the relevant precedents a lot faster than a junior associate flipping through a commentary.
But it cannot make the call. And if the call is wrong, the plaint is returned, Order 7, Rule 10, the entire system resets. My real fear here is that your 2026 toolkit gives lawyers a false sense of confidence. They use Wisp Flow to dictate a plea, Claude to structure it, and Gamma to present it. It looks slick, it looks modern. But if they haven't respected the foundation, Section 11, res judicata, they are just building a beautiful house on a sinkhole. If the issue has already been decided, no amount of AI generation can legally reopen it. The CPC stops the infinite loop.
And I would argue the CPC creates the infinite loop. The appeal structure, the endless revisions, the mutatis mutandis applications. You say the CPC stops the loop, I say it actively feeds it. We have tools like Ideogram 2.0 that can visualize complex scenarios like a car accident or a convoluted property dispute with incredible clarity. We could use that for settlement in the drafting phase. We could resolve cases before they ever hit Order 14. But the code incentivizes the long haul. It incentivizes the trial phase because that's where the procedure is the thickest.
The procedure is thick because the stakes are incredibly high. You call it the long haul. I call it due diligence. The source material explicitly links Order XXX interim relief and Order 21 execution as remedies and execution. They are the ultimate goal. But you cannot have the remedy without establishing the right. The code is what defines that right.
The right exists completely independent of the code. The code is just a delivery mechanism, and it is a delivery mechanism comparable to sending a telegram in the age of instant messaging. We are looking at a tech chart that shows Google Chrome evolving into Arc browser. That is a fundamental shift in how we intuitively access information. The CPC is a static document. It doesn't evolve like software. It doesn't get a 2026 update that just patches the bugs in Order 18.
Actually, it does evolve, through formal amendment and through the inherent powers of the court under Section 151.
Inherent powers are a patch. They aren't an upgrade. We need a system where the bread and butter Order 21 is the actual focus, not the byproduct of 10 years of procedural litigation.
I see why you think that, but let me give you a different perspective on inherent powers. Section 151 is the safety net that proves the drafters of 1908 were actually visionary. They knew they couldn't predict the future. They certainly couldn't predict Claude or Nano Banana. So they gave the court explicit power to make orders necessary for the ends of justice. The CPC is compatible with 2026 precisely because it prioritizes justice over mechanism. It allows the human judge to override a procedural defect if fairness absolutely demands it.
That is a very romantic view of Section 151. In practice, it is often just another application to file, just another hearing to schedule. It's procedural duct tape.
Well, we are nearing the end of our time today, so let's look at the big picture here. You champion the 2026 toolkit, Whisperflow, Windsurf, Julius AI. These are undeniably impressive instruments, but they are merely instruments. The CPC 1908 provides the rules of the game. Without the concept of res judicata under Section 11 to stop endless retrials, the sheer speed of AI would only create infinite litigation loops. We would literally have AI suing AI in microseconds, creating a backlog that no human court could ever clear. The blueprint ensures the house stands. It ensures that when a decision is made, it actually means something.
And I maintain that the blueprint is for a building that no longer fits the tenants. We have Nano Banana and Whisperflow, yet we are litigating like it's 1908. We are forcing digital disputes into analog boxes. We desperately need a system where Order 21, the result, the execution is the focus, not the endless drafting of Order 7. The tools have changed the fundamental nature of truth and evidence. If the code cannot accommodate the speed and transparency of the 2026 stack, then the code is not a foundation, it is a fossil.
A fossil is just a bone that has stood the test of time. It is proof of survival.
Or it is something that belongs in a museum, not an active courtroom.
And that is exactly where we find ourselves. Is justice defined by the stability of its ancient code, or by the efficiency of the tools used to achieve it? Can the 1908 CPC survive the 2026 tech stack, or will the immense pressure of these new tools fracture the old foundation?
We will leave that for you to decide. Thank you for listening.
Join us next time on The Debate.